Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning or today for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your most serious type of offenses, whereas your misdemeanors are normally referred to as your petty offense, as a petty offense. Does not mean that it is not serious. It just means that it is not as serious as a felony offense. When I use the term serious, what I'm talking about the facts of the case, the range of punishment that a person can be given if convicted of the felony or misdemeanor. Now, your felony cases are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. Person is convicted of a third-degree felony. The range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. Person is convicted of a second-degree felony. The range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. Person is convicted of a first-degree felony. The range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Person is convicted of a capital murder, which is the highest felony. The range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, your case is not a felony case, so you don't have to worry about the punishments that I just mentioned. Your case is a misdemeanor case, and misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. Fine from $0 to $500. You cannot be given any jail time. Class C misdemeanors are cases that are handled in the city court, which is the municipal court, or the JP court, which is justice court. Those cases come to this court if a person is convicted in one of those 2 courts, the JP or the municipal, and they appeal their case. In essence, they want to have a higher court to try the case, and they get a whole new trial. Now, the punishment range stays the same. It's by fine only. Now, if a person fails to pay the fine, or if the fine was converted to community service and they fail to perform the community service, then the court can issue what is called a capious pro fine, or warrant for your arrest to pay the fine. Or you will be required to pay the fine or sit out the time in jail. And you will be credited at $100 per day for every day that you sit in jail on your case. So for example, if you are fined of $200 or fine and court costs of $200, that simply means that you would have to spend 2 days in jail if you don't perform the community service or if you don't pay the fine. And if we issue a capious pro fine. Now, the next misdemeanor above the Class C is a Class B misdemeanor. The range of punishment, if convicted of a Class B misdemeanor, is minimum 0 days to a maximum of 180 days in the county jail, or a fine from $0 to $2,000, or you can be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the highest misdemeanor, the range of punishment is minimum 0 days to 365 days in the county jail, or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation, and the other type of probation is called adjudicated probation. Unadjudicated probation is normally referred to as deferred probation. And basically what happens if you are given that type of probation, you will not have a conviction on your record. And if you successfully complete the probation, the case will be dismissed and you may qualify for a non-disclosure. And basically what a non-disclosure is, it means that the government or the state, we cannot disclose the fact that you were on deferred adjudication to the general public. Notice I say general public. It can't be disclosed to the government because the government can't have access to it. And there are a list of agencies that can have access. That list is in the government, is in the Code of Criminal Procedure. The other type of probation is called adjudicated probation. With adjudicated probation, you will have a conviction on your record. However, if you successfully complete the judge can set aside the conviction, and basically the judge can do that by giving you what is called judicial clemency. And in order for that to happen, you have to complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged from the probation. Once those 3 things happen, the court has the discretion to set aside the conviction, and you will not have this conviction on your record, on your criminal record. However, if you get a subsequent offense, if you get another offense, a conviction later on, then this case can be resurrected, revived, brought back up, and used against you. And if you try to get a license with CPS, that's Child Protective Services, they can deny giving you a license. If you have a license, they can suspend or revoke the license that you have. As a defendant in a criminal case, you have other rights. One other right that you have is a right to have an attorney. It's a document that's on the clipboards that's out there near you. Each one of you who are here should have a clipboard. On the clipboard, the first page is titled Judge's Explanation of Rights to defendant without attorney. So as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may waive your right to an attorney, which means you may give up your right to have an attorney to represent you, and you may represent yourself. That document further states that if you want to represent yourself and you have enough money, well, if you want to hire an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date so that you will have enough time to hire an attorney. If you want an attorney and do not have enough money to hire an attorney, you will need to fill out a financial questionnaire. The financial questionnaire is the third document on the clipboard. It is titled Jefferson County Affidavit of Indigence. You will have to fill out that document, the first page and half of the second page, and then the court will review that document, and then the court will determine whether or not you meet the eligibility requirements for the appointment of a court-appointed attorney. If you want to waive your right to have an attorney or give up your right to have an attorney and represent yourself, then you will have the opportunity to speak to one of the three prosecutors that are in court sitting at the table that's in front of you. You may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. The written waiver of your right is the second page on the clipboard, and it is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive your right to have an attorney to represent you and you desire to represent yourself, you may change your mind at any time and request that an attorney be appointed by the court to represent you. At the bottom of the first document, in bold letters, it states, defendant's choice. Mark initials next to only one choice. If your choice is to hire an attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, to represent you, then you will place your initials on the fourth line to the left. If you want to waive your right to an attorney, that is, give up your right to have an attorney to represent you and you want to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines at the bottom of that first document, then you will sign your name on the line that is titled defendant. And you will date it today's date, March 5th of 2024. For those individuals who will be waiving their right to an attorney or giving up their right to have an attorney to represent you, and you will be desiring to represent yourself, you will have to read and sign the document on the clipboard that is titled Waiver of Counsel for purpose of entering a guilty plea or proceeding to trial. And this document states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, meaning that I'm doing it of my own free will, and intelligent means that I know what I'm doing. So it says my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 4th day of March of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, March 5th of 2024. As a defendant in a criminal case, you also have a right to have a trial by jury. That area where those 12 chairs are seated, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence. They will listen to the arguments. Then they will retire to deliberate. And then they will decide to either find you not guilty or guilty of your charge. As a defendant in a criminal case, you have a right to waive or give up your right to have a jury trial. And by waiving or giving up your right to have a jury trial, that simply means that you will not be having a trial by jury. And so therefore, your case will come before the court in one of 3 ways. One way it can come before the court is by way of a trial without a jury. We call that a bench trial. It's a trial by judge only. The judge will listen to the evidence. The judge will listen to the arguments. And then the judge will decide whether or not to find you not guilty or guilty of your charges. You also have a right to waive or give up your right to have a bench trial. And another way that your case will come before the judge is by way of an unagreed plea bargain. An unagreed plea bargain, what a plea bargain is, it's an agreement that you work out with the district attorney's office or with the state or with the government to settle your case. If you are unable to work out an agreement with the district attorney's office to settle your case, then we call that, and you still want your case to come before the judge, we call that an unagreed plea bargain. The judge will decide what your punishment will be in your case. The punishment will fall within the punishment range of your case, if it's a Class C, Class B, or Class A misdemeanor. The other way that your case will come before the third way that your case can come before the judge, if you waive your right to have a jury trial, is by way of an agreed plea bargain agreement. And what that means is you and the state or the district attorney have worked out an agreement to settle your case. Your case will come before the judge. The judge can do one of two things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. If the judge rejects the plea bargain agreement, then you will have a right to withdraw or to take back your plea. For example, let's say you and the state have worked out a plea bargain agreement for you to be placed on probation. And the judge says, well, I reject that plea bargain agreement. I'm not going to follow that plea bargain agreement. Then as a defendant, you can tell the judge, well, I withdraw or I take back my plea since you're not accepting my plea bargain agreement. You can do that. Now, if the judge accepts the plea bargain agreement and you decide within 30 days that you would like to appeal your case, that is, have a higher court than this court to review your case to see whether or not you've been wrongfully convicted or whether or not this court has committed an error by convicting you. Now, in order for you to appeal, if the judge follows the plea bargain agreement, you will have to get permission from the judge or the court to appeal your case. If the judge gives you permission to appeal your case, then your case will leave this court and go to the Ninth Court of Appeals, which is right above us on the third floor. The Ninth Court of Appeals will review your case. And the Ninth Court of Appeals can do one or two things. They can grant your appeal or they can deny your appeal. If the Ninth Court of Appeals grant your appeal, then they can just simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal this case to a higher court than the Ninth Court of Appeals. The higher court that you would have to appeal to, you would have to file what is called a pro se petition for discretionary review. That means that you'll be representing yourself. That's what pro se means. You will not be represented by an attorney, and you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted or whether or not this court committed an error by convicting you or whether or not this court wrongfully convicted you. And if they grant your pro se petition, they can do one of two things. They can either grant the pro se petition or they can deny it. If they grant the pro se petition for discretionary review, then, as I mentioned earlier, they can send the case to the Ninth Court of Appeals for them to review the case. or they could send it back down to this court for this court to give you a whole new trial. Now, you also have a right to have you also have a right to have witnesses to come to your court. And your right to have witnesses sit in that chair that has the microphone in front of it. That chair is called a witness stand. And what witnesses will do, they can either testify for you or against you. If you're representing yourself, you can ask some questions. If you have an attorney representing you, your attorney can ask them questions. We either call that direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. And by doing so, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have against you. You also have a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify against yourself in the case that the state has filed against you. State of Texas, the government, the DA's office cannot force you to testify against yourself. They can't force you to take the witness stand. If you invoke your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And that simply means that if you waive or give up your Fifth Amendment right against self-incrimination, you will be testifying in the case that they have against you. We also have you also have a right to have discovery. Discovery means that you have a right to see the evidence that the state has against you. You have a right to have access to your statement, witness statements, police reports, lab reports. You have a right to have access to audio recordings, video recordings, or any instruments that the state will be using against you in the case that they have against you. And you also have a right to waive or give up your right to have discovery. By waiving and giving up your right to have discovery, you're basically saying that you will not have access to the discovery or to the evidence that the state has against you. Now, as a defendant in a criminal case, and everyone that's here, you've been arrested, you're out of jail on bond, you're either out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a pure bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance. Now, every day that you spent in jail, even if you spent 1 minute in jail, that's considered one day. So every day that you spent in jail, you will be credited as 1 day in jail, and that jail time that you serve can be used as credit towards your punishment. So, for example, let's say you're in the state, reached a plea bargain agreement, you serve 5 days in jail, and the state is offering that you serve 5 days in jail. That simply means that you will not have to serve any more time in jail, because you'll be given credit for the 5 days that you've already spent. So therefore, you'll be given credit for time served. In essence, you've already served the time. You won't have to spend any more time in jail on this case. Now, if the state is offering 7 days in jail and you spend 5 days in jail, that simply means that you would have to spend 2 days in jail. every day that you spent in jail can be credited at $100 per day toward your fine and court costs. So, for example, if you spent 5 days in jail, that's $500 that can be credited to your fine and court costs. So, if the state is offering fine and court costs of $500, that means that you will not have to pay any more money. Why? Because you've already spent 5 days in jail, and that's $500. And so the fine and court costs of $500 will be taxed and retired, which means that you won't have to pay it because the time that you spent in jail has already paid it off. Now, if the state is offering fine and court costs of $700 and you spent 5 days in jail, which is $500, then if we take 500 from the 700, that means you have to pay $200. Now, you'll be required to pay $200 on the day that your case is disposed of in court. However, if you cannot pay the $200, then on that day, then we could put you on what is called a payment plan. In essence, you can pay off so much in monthly installments until the $200 or whatever the remaining balance is paid off. Now, for some people, you may not be able to pay the balance off because you are unemployed and you do not have the money to pay the balance. And so that's not a problem because the court can convert your fine and court costs to community service. And so for every 1 hour of community service that you perform at a nonprofit organization in the Jefferson County area, $12.50 will go toward your fine and court costs. So for example, if you work 8 hours, community service, that's $100 that can go toward your fine and court costs. So in the scenario that I gave you earlier, you owe $200, you work 16 hours or 2 days, 2 8-hour days, that will pay off the balance of $200 because you get $12.50 for every 1 hour that you perform. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. So let's say you have never been in trouble before. This is your first time getting into any type of criminal trouble. Jefferson County has a program that is called pretrial diversion. With that program, they will dismiss, when I say Jefferson County, I'm talking about the district attorney's office. With that program, they will dismiss your case. And if you successfully complete the program, you can get it expunged from your record. Expunged means erased, deleted, or wiped off from your record. In order to qualify for the program, you have to get an attorney to assist you at getting into the program. It cannot be for an offense for unlawfully carrying a weapon or resisting arrest. And it has to be your first time getting in trouble. Now, if you meet that eligibility requirement, you can talk to the court about that program, and the court can direct you to the right person in the district attorney's office so that you can make an application, or your attorney can make an application on your behalf. If you are a veteran of any one of the branches of the military, Jefferson County District Attorney's Office has another program that is called Veterans Court. It's also part of the pretrial diversion program. With that program, the only criteria is you being a veteran of any one of the branches of the United States military. And with that program, once you get into the program and complete the program, they will dismiss your case. And you may qualify for what we call a non-disclosure. And I mentioned earlier, non-disclosure is we cannot disclose the fact to the general public that you were on deferred adjudication for this program. Now, and we also have information on the Veterans Corps program as well. If you're interested in that program, just let us know, and we can point you in the right direction to talk to the right people to see if you can get into that program. This court, County Court at Law number 2, has a program that is called the CSI program. CSI stands for Community Safety Initiative. It's the program that I started within the first 100 days of taking office. The program started in March of 2017. That program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. Now, the way the program works is we have partnerships with local agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop Center is our local or our regional mental health center. We have some individuals from here who's in the jury box. They're going to come to you in a few minutes and tell you more about the program and programs that Spindletop has to offer. But basically, the program entails that Spindletop will do a private interview. They can do an assessment. They can develop a treatment plan, outpatient, inpatient, for individuals who have mental health issues. Now, you do not have to be incompetent or insane. You can merely have problems with anxiety, depression, etc. They can assist you and help you with your mental health needs. Spindletop also has another program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. Along with that program, the ATAR program, we have a partnership with our local drug and alcohol council, who has a program that is called OZAR. OZAR stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. Now, the reason why we have the mental health, drug and alcohol recovery program, because it is not uncommon for people to have what is called a dual diagnosis or co-occurring disorders. Sometimes individuals could use drugs, and it can lead to what is called a drug-induced psychosis. In essence, you can develop mental issues. So sometimes they run hand in hand, and so we have both of those programs to assist with either one or with both. If you are unemployed or if you are looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas that I've just mentioned, they will assist you at getting a job in the area that you're trained in. If you have not graduated from high school and you would like to get a GED, a graduate equivalency diploma, CICE also has a GED program. All of these programs that I just mentioned are free. It does not cost you anything. Only thing it does cost you is time. And I like to say in this court, we do not just give time, we take our time. And that simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say in this court, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, then we will make a difference in their home. And if we make a difference in their home, then we will make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs that I just mentioned, just let the court know, and we'll be happy to assist you at getting in any one of these programs. And the other beauty of this program is this. All of the programs that I just mentioned, not only they are free, but they can be used as community service. So if you are unable to pay your fine and court costs, it's converted to community service. While you are in GED class, or while you're getting mental health treatment or drug and alcohol treatment, or while you are being trained for a job, every 1 hour that you spend being trained for a job, getting treatment, going to class, whatever, 1 hour, $12.50 is going toward your fine and court costs. 1 hour is going toward the community service. $12.50 is going toward the fine and court costs, and you're in the program. So I like to tell people this: you're killing 3 birds with 1 stone. You're doing one thing, but you're getting credit for 3. Getting credit for the program, the program, community service, and the fine and court costs. And so if you're interested, just let us know. And as I mentioned earlier, we have some folks from Spindletop. We have Deputy Hinton and Chris. They're going to come to you and they're going to tell you more about the program that Spindletop has to offer. Deputy Hinton and Chris. You're welcome.
Morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here at the sheriff's office. This is my coworker here, Chris. Now, Chris is a qualified mental health professional with Spindletop. The reason we are both here today in this courtroom is because the judge cares about every single person in the event. But the judge has found what statistics prove is those who have legal issues commonly have mental health needs, such as use disorders, or sometimes just a lack of community resources that help you get people.
So, as Judge said, mental health needs, they look like anxiety, depression, things that everybody deals with at some point in their life. Now, I know that usually, when hand these out immediately when you guys came in, there was a slight time issue. And I have something that everybody in the this is a good sign that the consent form, I just allow them to contact you or talk to you. They came there, and said, you don't want it, just leave it. But there's a lot of really great community resources. I know you mentioned inpatient and outpatient. We get information. We're not going to send it anywhere. That's not what we do. But the big thing here is if we get your information, whether it's for yourself or for someone you care about. It doesn't matter if you're in here as a defendant or as support. The big thing is that you're here. We know that this is not a moment that is easy for anybody, but you all make a point to show up. And we want to make sure that it feels productive and you get to take something away from it. So that's why we're in here and as a loophole, essentially. There's a lot of really great community resources that are well funded, but they're not well advertised. And sometimes even just finding and fairly junky reviews. Sometimes the resources people need is just to talk, and that's what we're here for. I know that we do assessments, we do treatment plans, we do all that, but if that's not what you need, it's me, here, we're also here for that. It's about just letting us know.
So maybe this is your first time to be here, maybe it's your 10th time to be in court. You're still hope. In fact, what we're offering today has the ability to change your life, but we're going to need something from you. We're going to need you to share that need with us so we can best figure out how to serve you and get you connected to the resources that are best fit your situation. And Chris is going to explain exactly how you can do it very privately.
So I was asking for hands up to everybody, right? It functions as a baseline of the consent form, that you know your information is protected under state law. It will not be shared with anybody else. I'm the only one that's needed. The big thing there is that the only thing you're consenting to is me contacting you once or speaking to you privately. we're not gonna interpret for concept, we're gonna interpret ability, if it works better, it works to me at a different time, you can look at it. But this is just letting us know what you need, this is just letting us know how we can help. I know that in Jefferson County is one of those things where you may be in court in Jefferson County and not be anywhere close to here. That doesn't mean that we can't work with you, that we can't find something, because we're not limited just to this area. Like I said, there's a lot of great resources in Texas and the side of the US. If you need something, you're having trouble finding it, we can help. The big thing is that we just need you to help us. Now, it doesn't matter again if you're here as a defendant or you're here as support, it doesn't matter if you need information for yourself or someone you care about. You don't really, if the only thing we can do is get you information that you can pass along, then that's still more than what was done before.
I have a flyer here that I want to get everyone before you leave here today. On the back, it tells you some of the advantages of actively participating. But also on the front, it has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help you need.
The good thing about that number, again, it's not an Egyptian gun, that number is almost statewide. I say almost statewide because we all know that Texas has plenty of dead zones where no numbers get through. But it doesn't matter if you, it's Thanksgiving Day, it doesn't matter if you call them at 6 a.m. on Christmas Day. Wherever's going on, they will work with you in the moment. Now, that is a crisis number, though. If you have something you need and you need information for it, let me know ahead of time. And we can work together, we can find it. The big thing is we are state funded. Anything we help set up, anything we help set you up with is either be state funded or letting fees go, because we're not going to be trying to add financial stress to this. There are resources available. They're just difficult to get a hold of sometimes. But we understand that sometimes we all have things we need in our lives. So if you tell us, we'll do our best to work with you.
In just a little bit, the court is going to go into recess, and when it does, we'll be coming out there. We'll be passing that form out to you. I'll be handing this to you as well. And
Yeah, if you have any questions or anything you want to talk about, we'll be over here in the jury box. I know that sometimes it's just being in court in general can bring up a lot of different emotions, but sometimes I think we have a better handle on it. It's the environment, right? If anyone starts to feel anxious, if you're watching, if you need them to sit next to you, or you just, whenever the recess happens, if you need to talk, just let me know. We're really the only thing we're here to do is help. And we appreciate the trust. And we're looking forward to getting to talk to you and everyone.
thank you. Thank you,
Okay.
Your Honor.
Thank you, Chris and Deputy Head. Okay, ladies and gentlemen, the paperwork that you have on your clipboards, we're gonna pick that paperwork up. Now, if you need some assistance at filling the paperwork, we have our court personnel who's here, who'll be happy to help you. Now, it's gonna take us a little time to pick the paperwork up and evaluate it. And then, once we do that, then you'll be put in one of the 3 categories. Either your case is gonna be reset to give you time to hire an attorney, or we have to see whether or not you qualify for a court-appointed attorney, or you'll have an opportunity to talk to the prosecutors who represent yourself. Now, there are restrooms outside in the hallway, so if you need the restroom, they're outside of in the hallway. The men's restroom is in front of County Court at Law number 3. And the female restroom is on the opposite side of the hall in front of the 172nd District Court. Now, please do not leave the courthouse. If you leave the courthouse, and if we call your name, and you do not answer, your bond can be forfeited, and if your bond is forfeited, a warrant will be for your arrest. You'll be arrested and placed in the Jefferson County Jail. So again, if you need assistance with filling the paperwork out, just let us know. There are restrooms in the hall. And again, do not leave the courthouse. At this time, we'll be in recess. Jefferson County Court at Law number 2 is back in session. Recorded in session. In clause number 24, CCCR 0038. Case is style of state of Texas versus Aaron David Diaz. Mr. Diaz, would you please come forward? Mr. Diaz, your full name is Aaron David Diaz? Mr. Diaz, would you please raise your right hand? Mr. Diaz, do you swear or affirm to tell the truth, the whole truth,
Yes.
and nothing but the truth to help God? Mr. Diaz, you may put your hand down. How are you doing, Mr. Diaz? Doing all right? That's good. Mr. Diaz, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah, I filled out the first one and I told her that, I was gonna use an attorney, but I told her that I accidentally put them all out. So I'm using an attorney.
Understand. Now, is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that states that you have hired an attorney and the attorney that you hired is attorney Tom Burbank?
Yes.
Before you signed this document, did you read the document?
Yes.
And did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay. Mr. Diaz, I've read your answers. Your case is going to be reset to give you an opportunity to talk to your attorney, Mr. Burbank. Mr. Burbank is going to file a letter of representation stating that he has been hired to represent you. Now, before I send you over to the court coordinator to get your case reset, I need to give you some bond conditions. I'm going to go over these bond conditions with you. Mr. Diaz, the bailiff just handed you a document that is titled Standard Bond Conditions in County Court at Law number 2. Do you see that title?
Yes.
Okay, I'm going to go over this document with you, and it reads as follows. Following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yeah.
Now, condition number 3 and number 4 does not apply. However, condition number 5 does apply, and it states as follows. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Diaz, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, are you ready for it?
Yes, sir.
Mr. Diaz, you're going to stand in front of our court coordinator on the end. Once you reset your case, you're free to go and you have a blessed day. Next case is cause number 24CCCR 0104, case of style of state of Texas versus Bruce Wayne Green. Green, would you come forward? Mr. Green. Your full name is Bruce Wayne Green? Mr. Green, would you please raise your right hand? Mr. Green, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Green, you may put your hand down. How are you doing, Mr. Green? You doing fine? That's good. Mr. Green, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
Or are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Mr. Green, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Green, your case is going to be reset to give you an opportunity to hire an attorney. Mr. Green, have a seat in that chair by the first chair on the wall. Next case is cause number 23CCCR 2532. Case is styled the state of Texas versus Gabriel Joseph. Joseph, would you please come forward? Mr. Joseph, your full name is Gabriel Joseph?
Yes, sir.
Mr. Joseph, would you please raise your right hand? Mr. Joseph, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Joseph, you may put your hand down. How are you doing, Mr. Joseph? That's good. Now, Mr. Joseph, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Joseph, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line stating you would like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigent. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature on a line next to a box. Well, above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Joseph, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Joseph, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Laurie Perazzo. Attorney Perazzo will be given information to contact you. You'll also be given information to contact her. The court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Now, before she gives you that information, then they give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law number 2. Can you see that title? Okay, I'm going to go over these bond conditions with you, and it reads as follows. Following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, I do, Your Honor.
Condition number 2, the defendant shall submit to testing of drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, I do, Your Honor.
And condition number 3 does not apply. Condition number 4 does not apply. However, condition number 5, is that the right one? Yeah. Yeah, condition number 3 does apply. Let me go back over that. Condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states as follows: the defendant shall wear a global positioning monitoring assisted device at the defendant's expense, with written verification being submitted to the court within 3 days. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, Mr. Joseph, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Our court coordinator is going to give you that information to contact your attorney. Please have a seat. Oh, just please go to her window. Once you finish there, you're free to go, and you have a blessed day.
Right.
You're welcome. Next case is cause number 23CCCR 1982. Case of style of state of Texas versus Christian Uribe Lozama. Mr. Lozama,
Yes,
your full name is Christian Uribe Lozama.
yes, sir.
Mr. Lozama, would you please raise your right hand? Mr. Lozama, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Mr. Lozama, you may put your hand down. How are you doing, Mr. Lozama?
I'm doing good.
That's good. Mr. Lozama, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, I do, sir.
And is this your signature online as titled defendant?
It is, sir.
Are these your initials online stating you'd like to apply for a court-appointed attorney?
They are.
I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, I do, sir.
And on page 2 of the same document, there is a signature above the line that is titled defendant signature. Is this your signature?
Yes, it is, sir.
Mr. Lozama, before you sign and initial all these documents that I just showed you, did you read the documents?
It is.
And did you understand what you read? And was everything in these documents true and correct
Yes,
to the best of your knowledge? And Mr. Lozama, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you, in this case, Attorney Marvin Provo. Attorney Provo will be given information to contact you, and you will also be given information to contact her. The court coordinator will give you that information. Once you get that information from the court coordinator, you'll be free to go, and you have a blessed day.
you too, sir. Thank you.
Please have a seat in that first chair. Next case is cause number 24CCCR 0118. Case of style of state of Texas versus Juan Barrientos. Mr. Barrientos, your full name is Juan Barrientos?
Yes, sir.
Mr. Barrientos, would you please raise your right hand? Mr. Barrientos, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Barrientos, you may put your hand down. How are you doing, Mr. Barrientos?
All right.
That's good, Mr. Barrientos. I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line as titled defendant? Are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature? Mr. Barrientos, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Barrientos, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will be given information to contact Mr. Reynolds. A court reporter will give you that information. Once you get the information from the court reporter, you'll be free to go, and you have a blessed day. Please have a seat in that third chair on the wall. Next case is cause number 24CCCR 0048. Case is style of state of Texas versus Jesus Ignacio Garcia. Mr. Garcia, your full name is Jesus Ignacio Garcia?
Yes.
Mr. Garcia, would you please raise your right hand? Mr. Garcia, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Garcia, you may put your hand down. How are you doing, Mr. Garcia?
All right.
You doing all right?
Yeah.
It's good, Mr. Garcia. I have before me two documents. First document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Or are these your initial? Okay. Are these your initials
Yes.
on the line that state you would like to waive your right to an attorney, represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? Mr. Garcia, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct?
Yes.
To the best of your knowledge? Okay, Mr. Garcia. You'll have an opportunity to talk to the prosecutors in this case. Just please go back and have a seat where you're sitting, and one of the prosecutors will call you and talk to you. I'll keep this here. Next case is cause number 23CCCR 0284, case of style of state of Texas versus Blake Alexander Markland. Mr. Markland, your full name is Blake Alexander Markland.
Yes, sir.
Mr. Markland, would you please raise your right hand? Mr. Markland, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir.
Mr. Markland, you may put your hand down. How are you doing, Mr. Markland?
I'm doing okay.
That's good, Mr. Markland. I have before me two documents. First document is titled Judge's Explanation of Rights to Defense Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yeah, that's a signature.
At the bottom of this document, there's a set of initials on the line that state you like to waive your right to an attorney and represent yourself. Are these your initials?
Yes, those are the signatures.
Hmm?
Those are my initials.
Okay. And I also have before me a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, I recognize it.
And is this your signature on the line that's titled Defendant?
Yes, that is your
Mr.
signature.
Mr. Markland, before you sign and initial all of these documents that I just showed you, did you read the documents?
Yeah, I read them.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Mr. Markland, just have a seat in the chair that you were sitting in, and one of the bailiffs one of the court prosecutors is going to talk to you about your case.
Okay.
All right. Next, cause number 24CCCR 0068. The case is style of state of Texas versus Lindsay Janelle Levere. Ms. Levere, your full name is Lindsay Janelle Levere?
Yes, sir.
Ms. Levere, would you please raise your right hand? Ms. LaVere, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. LaVere, you may put your hand down. How are you doing, Ms. LaVere?
Doing good. How are you?
I'm doing fine. Thanks for asking. Ms. LaVere, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line state that you like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that's titled Waiver of Counsel for purposes of entering guilty plea or proceeding in trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Ms. LaVere, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Okay, Mr. LaVere, just have a seat where you were sitting, and one of the prosecutors is going to come out and talk to you about your case.
Okay. Thank you.
You're welcome. Okay, court will be in recess. Jefferson County Court, Law number 2 is back in session. The court is in session with the arraignment docket. Court is in session and cause number 24 CCCR 0068. Case is styled the state of Texas versus Lindsay Janelle Levere. Ms. Levere, would you please come forward? Ms. Levere. Your full name again is Lindsay Janelle Levere.
Yes, sir.
Ms. Levere, would you please raise your right hand? Ms. Levere, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Levere, you may put your hand down. Ms. Levere, I have before me document that is titled Judge's Explanation of Rights, Defense by Attorney, and waiver of counsel for purposes of entering guilty plea or proceeding to trial. Now, before I get into these documents, as a defendant in a criminal case, you have a right to have a record be taken by a court reporter. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right?
Yes, sir.
Okay. Now, Ms. Levere, again, these two documents, Judge's Explanation of Rights, Defense by Attorney, and waiver of counsel for purposes of entering a guilty plea. Prior to you signing and initiating these documents, you read these documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
I also have a document before me that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. Before I get into that, Mr. Andrew Hubel is from the District Attorney's Office. Mr. Hubel, how are you doing?
Do more, Judge, yourself.
I'm doing fine, thanks for asking. Now, Ms. Levere, the state has filed the information sheet, and in this information sheet, it alleges that you, Lindsay Janelle Levere, on or about November, I'm gonna send this one back to you. On or about November 7th of 2023, while you were in Jefferson County, Texas, that you committed a Class B misdemeanor offense of possession of a controlled substance, penalty group 4, less than 28 grams. Ms. Levere, do you understand what you've been charged with?
Yes, sir.
And to discharge Ms. Levere, how do you plead? Guilty, not guilty, or no contest?
Yes.
Now, you're pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight, contest these charges?
Yes, sir.
And this charge, Ms. Levere, occurred in Jefferson County, Texas. Is that correct?
Yes, sir.
Now, Ms. Levere, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are 2 sets of initials. One set is below a paragraph that is titled Waivers, and your initials LL are on a line next to a box that's checking over contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
The next set of initials is below a paragraph that is titled Discovery Admonishment, and your initials are on a line that reads as follows. I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or nolo contendere, which is no contest. You place your initials on this line.
Yes, sir.
On page 3 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that You're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Ms. Levere, before you signed and initialed all of these documents that I just showed you, did you read these documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Levere, are you a citizen of the United States?
Yes, sir.
Stay up for stage one.
Ms. Levere, the state is offering State's Exhibit Number 1. State's Exhibit Number 1 is the first document that I showed you on this tablet that you acknowledge. It's also the same document that have your initials in these 2 locations on page 2. And it has your signature on page 3. The state would like to use this document as evidence against you in this case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objections. State's Exhibit Number 1 will be admitted. Ms. Levere, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Ms. Levere, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
The agreement for a plea of guilty or no contest, the state has offered 180 days probate over 15 months with a $500 fine and 50 hours community service.
Okay. Ms. Levere, the Ms. Coordinator, what is the court cost in Ms. Levere's case? 277. Oh, she does, okay. 270, okay. Right. Okay. Ms. Levere, the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not serve any time in the Jefferson County Jail because you'll be placed on probation for 15 months. During the 15-month probationary period, you'll be required to pay a crime lab fee of $100. You'll be required to pay a fine of $500. You'll be required to pay a probation fee. You'll be required to pay court costs of $277. You'll be required to pay a probation fee of $60 a month, a urinalysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is a total amount that you will be required to pay each month while you're on probation, is $144 a month. Will you be able to pay the $144 each month?
I don't know. Right now I'm not employed.
Okay, do we, hold on a minute. Get her, see if she has an affidavit of indigence.
This is before you people do that, don't you?
Awesome.
Really wrong, man. Really wrong.
Okay. Miss Levere, I have before me a document that is titled Affidavit of Indigence. Mr. Prosecutor, could you please hand this document to Ms. Levere?
Yes, sir.
Ms. Levere, you recognize that document?
Yes, sir.
On page 2 of that same document, if you turn the page over, there's a signature above on the left-hand side above the line that is titled Defendant's Signature. Is that your signature?
Yes, sir.
Now, Ms. Levere, is everything in that document still true and correct today?
Yes, sir.
Okay. Mr. Levere, you can hand that document back to the prosecutor.
That's also correct.
Yes, oh, that's correct.
Okay. Now, Ms. Levere, the court is going to find that you are indigent. Based on the finding of indigency, the court calls in this case and the fine in this case will be converted to community service. The fine and court costs will be converted to 62 hours of community service. The probation fee of $60 will be reduced to the statutory minimum, $25 a month. Now, you'll be required to pay a crime lab fee of $100. The fine of $500 plus court costs of $277 is converted to 62 hours of community service. The probation fee will be reduced to the statutory minimum, $25. You'll be required to pay a reimbursement fee of $15 a month, a urinalysis fee of $15. No, you'll be required to pay a urinalysis fee of $15 a month and a reimbursement fee, a one-time fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $51 a month.
Yes, sir.
Okay, will you be able to pay the $51 each month?
Yes, sir.
You will also be required to perform 50 hours of community service in addition to the 62 hours of community service that was converted from fine and court costs. So you'll be required to perform a total of 112 hours of community service. Do you understand that?
Yes, sir.
You will also be required to adhere to the other standard terms and condition of probation. Now, Ms. Levere, do you understand the state's offer and the court's adjustments
Yes, sir.
that the court has made pursuant to Article 42.15 of the Texas Code of Criminal Procedure because the court found that you are indigent? And do you think that the state's offer and the court's adjustments are fair and just?
Yes, sir. Thank you.
And do you accept the state's offers.
Yes, sir.
Okay, Ms. Levere, I will follow plea bargain agreement that you have made with the state, along with the adjustments that court has made pursuant to Article 42.15 of the Texas Code of Criminal Procedure. Now, Ms. Levere, just go back and have a seat, and when the coordinator is ready for you, she's gonna ask you to come up to her window. And once you go to her window and finish at her window, once you finish following the directions of the court bailiff, you'll be free to go, and you have a blessed day.
All right, you too. Thank you.
You're welcome. What happened?
Oh, here, you got it.
I must have sent you marking. I meant to send you a Levere. Did I send you marking?
I hadn't even cooked it yet.
Mark, oh, you had it?
I had sent Levere and Miss.
I must have sent you the other guy, then. I must have sent you Garcia.
Yeah, and so I need to sign it here, on here, on paper.
Oh, you finalized it?
Yeah, that was an accident, though. I had meant to send it
Oh.
back to you.
Well, I'm gonna have to get him to
And I'll
to
make
come
a
up
copy.
before,
It's not leaving.
the court cost was converted to community service. Fine and court cost was converted to 62 hours of community service. Ah. Let's see. Next case is cause number 24 CCCR 0048. Case is style of state of Texas versus Jesus Ignacio Garcia. Mr. Garcia, your full name is Jesus Ignacio Garcia.
Yes.
Mr. Garcia, would you please raise your right hand? Mr. Garcia, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Garcia, you may put your hand down. Mr. Garcia, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Second document is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding Trial. You recognize this document?
Yes.
Now, Mr. Garcia, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Garcia, I also have before me a document that is titled Motion to Forfeit the Weapon, in this case to the Port Arthur Police Department. Mr. Garcia, do you recognize this document? And is this your signature on the line as titled defendant?
Yes.
Mr. Garcia, before you signed and initialed this document, did you read this document? And did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Mr. Garcia, you want the court to grant this motion to forfeit the weapon, in this case, to the Port Arthur Police Department? Mr. Garcia, I'm granting this motion to forfeit the weapon to the Port Arthur Police Department. State, I have before me a motion to dismiss this case for forfeiture of weapon. Is that correct?
It is correct.
Mr. Garcia, I'm signing this motion to dismiss this case pursuant to the plea bargain agreement that you made with the state. Okay, Mr. Garcia, we're gonna have to make a copy of this form, right? Just go back and have a seat. When she's ready for you, she's gonna ask you to come up to her window.
Appreciate it.
You're welcome.
Yeah, that's something.
Yeah, let's go. Let's see.
Garcia?
Why is this thing back? Why is Levere back? I thought I sang Levere.
It don't show me on my tab.
It's all mine.
Well, no, it was already.
Yes, sir.
You're
welcome. You too. Okay.
I think he usually does, he just sends you the.
Okay.
Oh.
No.
Okay. What's that?
Yeah.
Lake Alexander Markland, cause number 23CCCR 0284. Ms. Markland, your full name is Blake Alexander Markland.
Yes, sir.
Markland, would you please raise your right hand? Ms. Markland, do you swear affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Ms. Markland, you may put your hand down. Ms. Markland, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defense by Attorney. Recognize this document. And the second document is titled Waiver of Counsel for purposes of entering guilty plea or proceeding trial. You recognize this document.
Yes, sir.
Now, before you sign and initial these documents, did you read the documents?
Yes, I did.
And did you understand what you read?
Yes, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Now, Mr. Markland, you have a right to have a court reporter to dictate everything that's being said in court. You also have a right to waive or give up your right to a court reporter. Do you waive or give up your right to have a court reporter?
Yes, I will.
Okay. And Mr. Markland, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Blake Alexander Markland, on or about October 12th of 2022, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed to Class B misdemeanor offense of driving while intoxicated. Mr. Markland, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Markland, how do you plead guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty? Mr. Markland, I also have before me a document that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, I recognize it.
On page 2 of this same document, there's two sets of initials. The first set of initials are on a line next to a box that's checked guilty, and it's below a paragraph that is titled Waiver. Would you place your initials on this document? The second set of initials are on a line where, or below a paragraph that is titled Discovery Admonition or Admonishment. and your initials are on a line that states, I do not request discovery of the evidence. I waive my right to request discovery in this case and enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature on?
Yes, that's the signature.
On the next, let's see, on the next document, this document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes, that's the signature.
At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, I understand.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, I understand.
And Mr. Markland, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yeah.
And did you understand everything in these documents?
Yes, I understand.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
And Mr. Markland, are you a citizen of the United States?
Stay up for stage one.
Mr. Markland, the state is offering in State's Exhibit number 1 to be used as evidence against you in your case. State's Exhibit number 1 is the first document on this tablet that you acknowledge. It is the same document that has your initials on page 2 and your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use these documents as evidence in your case?
Yes.
Okay, no objections. State's Exhibit number 1 will be admitted. Mr. Markland, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Mr. Markland, I will accept your plea of guilty.
Question. Will there be any other stipulations like at my license back besides the interlock and the fee?
What, you talking about the plea bargain that you work out with the
Yes.
state?
The only stipulations are the things that we've already talked about.
So just the interlock and the.
Standard conditions.
Yeah, you'll have some
Probation
what we
fines.
call, conditions of probation, but I'm not there yet. Okay. Let's see. Let me do this here. Now, Mr. Markland, the court is going to accept your plea of guilty. The court will find that you are mentally competent to stand trial. The court will also find that your plea and waivers were freely and voluntarily given. And the court will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Yes, Your Honor.
And what is the agreement?
For plea of guilty, the state has offered 180 days probation over 1 year with a $750 fine, 5 days jail credit to be credited towards that fine, and 60 hours community service, the installation of an interlock in any device that the defendant owns or operates, and DWI standard conditions of probation, including testing and DWI education.
I just didn't know anything about it. No. Okay.
Yeah. What's the court cost? $392? Mr. Markland, the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a DPS fine of $100, a standard fine of $750. You'll be required to pay court costs of $392. You'll be required to pay a probation fee of $60 a month, a urinalysis fee of $15 a month, and a reimbursement fee of $15. You'll also be required to pay Jefferson County DWI Education and an initial evaluation fee of $125 on the day of the police. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $196 a month. Will you be able to pay the $196 a month?
Yes, I'll be able to do that.
You will also be required to,
No, Judge. One thing I just want to be clear, the 5 days credit, is that going towards that?
yeah, I hadn't got to that yet. Now, you'll be given 5 days credit towards your fine and court costs. Okay, so let me do this here. That's 16. Okay. Now, you'll be given 5 days credit toward your fine and court costs, which means you won't have to pay that fine and court costs. And by you not paying, being required to pay the fine and court costs, because the time that you spent in jail has already paid that off.
Right.
And so therefore, your monthly installments is going to be $150 a month
Okay.
instead of the $196 a month. And will you be able to pay the $150 a month?
Yes, sir.
Now, and I'll just repeat it. You'll be paying a DPS fine of $500, the fine of $750 plus 300. The fine of $750 will be reduced to $250 because you'll be you got 5 days credit.
Right.
And you'll be required to pay the court costs, $392. You'll be required to pay a probation fee, $60 each month, your analysis fee of $15 each month, and a reimbursement fee of $15. And that comes to a total of monthly installments of $150 a month. Do you understand that?
Yes, I understand.
And you'll be able to pay it.
Yes, I'll be able to
Okay.
pay it.
Now, you will also be required to perform 60 hours of community service. You'll be required to install an interlock device on any vehicle that you own or operate. You'll be required to attend and complete the DW education class. You'll be required to have an alcohol assessment, and you'll be required to adhere to the other standard terms and condition of DWI probation. All right. Now, do you understand the state's offer?
Yes, I understand.
Do you think that the state's offer in your case is fair and just?
Yes, but so there's no other requirement besides just the interlock to get my license?
You're gonna have some standard terms and conditions of your probation. Now, if you need to know what you need to get your license back, you need to talk to an attorney. Okay, they can give you advice on that. The court can't give you any advice on that.
Okay.
Okay. Now, again, do you understand the state's offer?
Yes, I
Do
understand.
you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Mr. Markland, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Markland, just have a seat, and when the court coordinator is ready, she's gonna ask you to come to a window. You're gonna follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day.
Thank you, sir.
And you're welcome. Okay, next case is cause number 23CCCR 1700, case of South State of Texas versus Terrence Daniels. Mr. Daniels was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., of course, better call the name of Terrence Daniels at the courthouse door. Terrence Daniels did not answer. Terrence Daniels did not appear in court since the court's been in session. The time now is 12:31 a.m. Excuse me, 12:31 p.m. on today's date of March 5th of 2024. Ms. Bailiff, would you please call the name of Terrence Daniels at the courthouse door? Terrence Daniels called to get at the courthouse door. Terrence Daniels did not answer. A reasonable time has passed to give Mr. Daniels an opportunity to appear in the court. He has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Terrence Daniels' bond will be forfeited. And cause number 23CCCR 1700. Next case is cause number 24CCCR 0036. Case of style of state of Texas versus Deanna Dobbins. Deanna Dobbins was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., of course, really call the name of Deanna Dobbins at the courthouse door. Deanna Dobbins did not answer. Deanna Dobbins has not appeared in court since the court has been in session. The time now is 12:32 p.m. on the day's date of March 5th of 2024. Ms. Bailiff, would you please call the name of Deanna Dobbins at the courthouse door?
Dobbins, Deanna Dobbins.
Deanna Dobbins' name was just called at the courthouse door by the court's bailiff. Deanna Dobbins did not answer. A reasonable time has passed to give Ms. Dobbins an opportunity to appear in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Deanna Dobbins' bond will be forfeited. A warrant should be issued for arrest in cause number 24CCCR 0036. Next case is cause number 24CCCR 0070. Case of style of state of Texas versus Ricardo Cuija. Ricardo Cuija was scheduled to be in court this morning for 9 a.m. for the court's arraignment docket. At or about 9 a.m., the court's bailiff called the name of Ricardo Cuija at the courthouse door. Ricardo Cuija did not answer. Ricardo Cuija has not appeared in court since the court has been in session. The time now is 12:34 p.m. on today's date of March 5th of 2024. Ms. Bailiff, would you please call the name of Ricardo Cuija at the courthouse door?
Ricardo Cuija. Ricardo Cuija.
Ricardo Cuija's name was just called again at the courthouse door. Ricardo Cuija did not answer. A reasonable time has passed to give Ricardo Cuija an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Ricardo Cuija's bond will be forfeited in cause number 24CCCR 0070, and a warrant shall be issued for his arrest. And this will conclude the calling of the court's arraignment docket in County Court at Law Number 2 of Jefferson County, Texas, on today's date of March 5th of 2024. Everyone, please have a blessed day.
Thank you.